Sorry to disrupt your piece. So actually, it's big one. Does it sound good? And I prepared printout in coverage of law of intellectual property rights. So, I confirm all you have recovered the printouts, and for the last student, I remind that the printout was not made in order, so you may need to work to make it order on pages. So actually covered in order. Page number. Sorry. And you've seen the projection law of intellectual property rights. So subtitle, about 2 pages, the topics and other important issues that need to be dealt in understanding international transactions and intellectual property rights were outlined. Actually, the international business is now very concerned of intellectual property rights, its protection, and also one of a area intensely contended by a scope of nations, and also in diplomacy between the developed and developing states. And it is one of a great area that developed countries intend to exploit to increase the national economy. And so the contention were negotiated in the worldwide round, as I've introduced the previous class, and actually the international community reached consensus about a framework, or what I call TRIPS agreement, trade-related intellectual properties. So you've seen the subtitle about that point in international property rights protection. In advance, we need to explore a Paris Convention and patent cooperation treaty, then Berne Convention and Universal Copyright Convention. So they're actually present the regime of the intellectual property rights protection. And also WIPO, World Intellectual Property Organization, is a kind of depository that the International Convention were administered and managed. And the area of law is actually very rationalistic, as I've said, and often the Syrian rules evolved over the United States context, now much influence and to exercise in shaping the international trade property right regime. So that is one task we need to consider in first priority. So we undertake to review the trademark protection and trademark dilution and copyright protection and patent protection, and also trade secrets. You see, the protection often means kind of a elevated status about the intellectual property. So it is in contrast with a trade secret, since trade secrets has some of a distinct domain that policymakers will deal with. And also, you see McDonald's corporations with shop at home, and also Bestsellers Incorporation versus Grapevines at DuPont case. And the cases involves a most notable aspect we need to understand. For example, what is a consumer's confusion? Confusion of trademark. Bestsellers typically deals with that issue, as you see on page 436, substantial likelihood of confusion. That is a central concept we need to rely on about administering kind of a contention. In the case titled Bestsellers, see, which was decided in Southern District, New York, in 00, what involves a trade dress, Bestsellers trade dress, and that is inherent distinctive. So deserves a legal protection about a trademark. So an important issue arises in points that you see in pages. What is that? A trademark law seeks to balance the protection of intellectual property and the need not to deter free and open competition. That is two concept in dualism in weighing the interest at a judicial point. You see what extent of protection of intellectual property need to be afforded. So actually the concept is quasi-property right, and we consider the efforts and time of the inventors, for example, involving patent right, and also the kind of novelty cases, and whether it is non-obvious or generic. That is the point. And also the trademark, the right of trademark may be obsolete in some cases, or if the trademark holders would not use it over a long period of time. So it is non-use would be one factor to negate its legal force in protection for a trademark, right of trademark. And also, we also need to consider the point in counteractive force, the need not to deter free and open competition. And this virtue might be favored by developing countries. So they often have grievances about enhanced protection, assertion, what alleged by developed countries. And they also have a larger metaphor about the common asset for use of humankind. As you see in the last case, in very extremes, Chinese authority claimed why the invention of a paper would not be protected. So the implication, of course, be that the intellectual property rights advocate ought to be a question. And also protection of trade dress is needed to secure the owner's goodwill in the business and to protect the ability of consumers to distinguish among competing producers. So trademark often is related in very commercial interest with the business reputation of the trademark holders and also a goodwill reputed in the area of a trade. So I now engage in apparel manufacturing corporation, Chanel or what else, Bear Garden. So it represents the tradition and skills and kind of quality of a products. So held through the centuries or the decades in cases. So this concept to recognize some economic virtue in that aspect. And also, you see in TRIPS agreement, the geographical indication. What is that? In some cases, a specific geographical location would be a greatest relations, inviolable and hardly be detached from the quality of a food and a product. The kind of new dealings actually were introduced in the TRIPS agreement as we review later. And also, you see some of important points of court ruling in this case. What is that? Is the factors to be established in a convincing force of proof to claim a trade dress infringement. What are they? Those that is trade dress is either inherently distinctive or that it has acquired distinctiveness through a secondary meaning, and that there is likelihood of confusion between defendants, a trade dress, and plaintiffs. In this area, the most governing act would be Lanham Act, about the protection of trademark. And according to that act, generic marks are not entitled to protection. So, to prove trademark infringements under U.S. law, a party must prove that another's use of the registered mark is likely to cause consumer confusion regardless the source of the product or service, product or service. So you need to know the factors often are determinative about infringement trademark. So the court has a kind of general ambit and standard about a review of a trademark infringement. What are those? Degree of similarity between the marks. That is most primary focus often, and actually in compliance with nature of the contention. And the intent of alleged infringer is not direct to find the dispute in objective perspective. However, this subjective element also is explanatory about the means of justice in this area. And the similarity of use of two products or services. The similarity in the marketing of the goods or services. So circumstance factors relevant with finding about the likelihood of confusion would be involved, as you see, and the degree of care likely to be exercised by consumer or purchaser, and evidence of actual confusion, and the strength of the registered mark. In understanding the laws of intellectual property rights, you now have four classes generally in the United States context. And the classification also pertains to the Korean system about intellectual property. So often we do not find any extent the differences between Korea and the United States in concerning the copyright laws, patent laws, and the legislative dealings about a trade secret. You see, in the first year of new millennium, Korean authority has legislated a trade secret, the law about a protection of trade secret. And so you would not be incorrect if you take both countries are in the same step and legal culture about protection of trade secret. So the first scope in intellectual property would come works of authorship protected under a copyright law. Works of authorship deserves a legal protection by the very ways of copyright act. And also, it has the distinctive flavor in dealing against other kind of intellectual property rights, for example, patent. It involves half in strength about the personality of the author, kind of economic aspect of law, and it's combined with nature of a personal dealings involving the author. And also, you in second class, you need to know the trademark law. Product marks, symbols, and trade names often comes into ambit of a trademark law. So legal protection was responded to the proper rights and obligations about the interest parties. And inventions are protected under patent law. What is the nature of patent and what quality of invention is necessary to be entitled as a patent right in some of the specific countries. That is often subject to the discretion and leeways of the specific national authority. However, we may see some convergence about the extent of protection and qualification to be paid. The concept is the invention is patentable, is a threshold issue to be resolved beforehand, and very important subject matter, often litigated in court proceedings. Korean authority has a separate system since the issue involves very difficult technical area of concern. So we now manage the special code, subject to uniform, of course, appeal system, in culmination of a Supreme Court of Korea. However, the appellate court and a trial district court would be waived to defer the jurisdiction to the Special Administrative Branch, Patent Office of Korea. And also, the United States notably has that kind of branch. United States is Patent and Trademark Office, as you see pages later. And also, confidential information and methods of doing business protected as trade secrets or by unfair competition laws. And in this technological era, with the new dealings, what we often call new statute rights, to cover a specialized creation, such as semiconductor chips, and mask works. As you know, it is actually the right which is transformative to respond with the new technologies and other science, the cultivation of a specific scientific field. So, to best understand the problems of protecting intellectual property right internationally, it is important to understand the basic intellectual property principles and common to most legal systems. So, a brief review of the intellectual property law of the United States would be a starting point, which is model country. This area of law. In the United States, intellectual property law is the most protective in the world. That is one point, as I pointed out, that now the international community shares to compromise. In the process of global legal negotiation, you see some of a favorable treatment about the unequal footing of economic states. So the developing countries and communist countries also have been granted this right to defer the mandates and other obligations for some years, in 5 years in some cases, and 10 years for the least developed countries. So it actually poses great challenges for those kind of marginalized states about instituting a Western standard of a intellectual property rights. So the immediate application of TRIPS would discriminate those kind of deprived countries. So in one way, the policymakers of WTO deliberated to manage the international economy in agreeable fashion, as you see. So, what is the context about federal statute law? It provides the primary protection for the four suite. What are those? Trademark, copyright, and patent. And you see some of a state law about the copyright In any case, both the forced three would be prescribed massively by federal statute law, and trade secrets are protected under state law. Trademark law protects words, names, and other symbols used to identify a company's goods and distinguish them from those manufactured by others. Unlike patent and copyright protection, trademark protection can be derived from both federal and state law. There will be trademark, which both authorities involved to regulate. For the maximum amount of protection, however, the trademark must be registered in the U.S. Patent and Trademark Office. As long as the trademark does not become generic, the trademark may be renewed perpetually. Federal copyright law protects works of original authorship from unauthorized duplication, modification, or distribution. Mere creation of the work results in copyright protection. However, placing a copyright notice on the work, registering it with a copyright office provides more complete protection. So it is in theory and law, the work need not to be registered to claim a copyright protection. However, it is practically required to increase the interest from a higher protection. So, and also the copyright notice would facilitate the potential, to discourage the potential infringement. So the practical point and a pure legal terms could differ in terms of business interests. And patent law protects inventions that are novel, useful, and non-obvious. Federal law lists statutory categories of patentable subject matter, including machines, manufactured articles, processes, and compositions of materials. And finally, a trade secret is any device or information that is used in business and gives its own owner an advantage over its competitors. Trade secret laws, it provides for a perpetual protection unless the protected information becomes a public law. So you see some points in comparison between a trade secret and copyright law. For example, the works of a original authorship could be intervened in excuse and justification about fair use of materials, kind of three excuses you would be exposed later, and it constitutes the critical points to litigate the copyright law. What is a fair use? To legalize the unauthorized use of the books and articles. And also, in some cases, patent right may be enforced by a mandatory commitment of nation. And also you see in trademark some differences about whether it is a government sanctioned interest or kind of a more softened nature of a intellectual property. So that is the aspect we need to consider to understand in comparative perspective across types of intellectual property rights. And another concept about trademark would be dilution. So the concept was intended to reinforce the legal protection about trademark holders. So kind of damages may be predicated upon some kind of act or commission of act. We may see property infringement of a trademark, and also in some cases that would be responded with imposing a criminal sanction. A kind of legal institution or systematized in one single act that you see on page 4 or 3A7, Federal Trademark Dilution Act. The act was based on Lanham Act, and the Lanham Act was amended to include this act. The act defines dilution as the lessening of the capacity of famous mark to identify and distinguish goods or services regardless of the presence or absence of competition between the owner of the famous mark and other parties, or likelihood of confusion, mistake, or deception. Trademark dilution, as defined in the FTDA, is founded on the premise that the diminution of value of trademark resulting from its unauthorized use constitutes an invasion of property rights and goodwill of the senior user. So in this act, it presents two important concepts, a senior mark and junior mark. A junior mark is what allows to infringe the senior award. The senior mark or user is the trademark owner bringing the claim of infringement of dilution. Although the senior user need not show actual loss of sales or profits, the mere fact that customers may associate the junior mark with a senior and famous counterpart is insufficient to establish dilution. The junior mark or user referred to here is the party accused of trademark infringement or dilution. So trademark dilution claim entitles the trademark owner to an injunction against another person's commercial use of his mark or trademark. And also in this act, two concepts were recognized. What are those? Tarnishment and blurring. Tarnishment arises when the trademark is linked to products of shattered quality or is portrayed in an unsavory context likely to evoke unflattering connotations about the product or service, or in a manner at odds with the image projected by the trademark. Blurring is a diminishing of selling power and value of the trademark by unauthorized use. An action for blurring pursuant to FTDA requires use of marks sufficiently similar to a famous mark to evoke a mental association of the two marks in the minds of consumers, thereby causing economic harm to the famous mark's economic value by lessening its selling power as an advertising agent for goods and services. Relevant factors in determining the exercise of blurring include actual consumer confusion and the continued likelihood of such confusion, the duration of the junior use, harm resulting to the junior use as a result of enjoining the use of its mark, and the delay, if any, by the senior user in initiating a litigation. So across types of intellectual property, you see similar scope of factors. Court often investigate to determine the standard of infringement and others. Well, in delusion claim about a trademark, the court firstly saw if the senior mark would be is famous or not. And the second point would be the junior user must be a commercial user. And thirdly, the commercial use is occurring in interstate commerce. And fourth, use by the junior user must begin after the senior mark has become famous. And finally, use by the junior user must cause delusion of distinctive quality of the senior mark. So the trademark owner must establish these elements to be entitled civil damages, or of course the trademark infringement may evoke some of a criminal sanctions. Penalty may be provided to counteract the evils of perpetration. In that case, you see one court opinion to guide the actual operation of perpetrator would not be relevant in determining, in finding a criminal liability. So whether it is trademark or not, entitled to legal protection, will be properly waived to penetrate the perpetrators to the criminal sanction. And in this line of deliberation, you need to focus on the U.S. Supreme Court's recent interpretation of the FTDA in Mosley versus a secret catalog. So in this case, the court elucidated the holders of senior and junior marks also should be aware that individual states have their own anti-dilution statute, the elements of which may vary from those set forth in the FTDA. But the court saw the interplay between state and federal system. And about copyright protection, your first point in grasp would be definition of copyright. What is copyright? It is a form of protection provided to authors of original works, authorship, fixed in a tangible form of expression. So you see black letter word, tangible form in printout, which is essential to create the context of a copyright protection. The works must be fixed in tangible form to receive federal copyright protection. Improvisational speeches or performances that have not been recorded or written are not protected. The 8 generic categories of copyrightable works include literary, dramatic, musical, choreographic, pictorial, motion, picture, sound recording, and architectural works. And also the code often entertains the policy that these categories are interpreted broadly. For example, computer programs may be registered as literary works. As induced, the copyright protection is available to both published and unpublished works. And also, copyright protection affixes to the work at the time of creation. You see no registration requirement as a matter of law. However, I have pointed to some practical necessities. And in copyright protection, most important statute would be a Copyright Act of 1976. Section 106 in this act gives the copyright owner the exclusive right to reproduce the work in copies, prepare the derivative works, to distribute copies by sale, rental, lease, or lending, and to perform or display the work publicly. So it is illegal for anyone to violate of any of these rights. However, the rights are not unlimited. So you see the sections 107 through 121 to prescribe limitations on copyright. There are three general exceptions to the exclusive rights of copyright owners. As I've said, the fair use doctrine often allows the user to adopt the copyrighted books or articles in some permissible way. And also, for sale doctrine also authorized the user to make legitimate use. And also, materials that are part of a public domain will be the scope of exemptions. The for sale doctrine terminates the copyright owner's protections over a copy of the copyrighted work once the work is legally sold. The purchaser gains the right to resell the copy. The Copyright Act states that the owner of a copy is entitled to resell the copy without consent of the copyright owner. So on page 441, you see a case entitled McDonald's Corporation versus Shop at Home. It explored the for sale doctrine in greater detail, including whether sales made in contravention of franchise agreement qualify as for sale, thereby terminating copyright protection. Although the intellectual property at issue in this case was a trademark rather than copyrighted, novelty goods, the case provides a thorough discussion of difficulties and risks encountered by a franchisor when violations of its intellectual property rights occur in the supply chain. So, you see, the plaintiff in this case was a franchisor, what he often used as a lunch place. You see? How have you patronized this facility, McDonald's? You may find street, neighborhood, and Shop at Home, whose defendant in this case is franchisee. And McDonald's asserts the franchisee infringed with trademarks of McDonald's in the course of his franchisement business. So McDonald's illustrates several points in contention and argued, for example, because it did not approve toys' initial sale until they were sold, those who made first purchase, the sales by the franchises to the defendants and other third parties were illegitimate, and therefore there could be no forced sale. So the defendant relies on the forced sale doctrine that the McDonald's already granted constructively kind of right to resell others. The forced sale doctrine would negate its claim about a prohibition of reselling or property in other ways. What do you see? Defendant Gary Fuller's apparently began purchasing the toys before they were available to the general public and offer them to the shop home network for sale. Mr. Fuller's used relatives to buy as many toys as they could obtain from the restaurant. In so doing, the relatives made purchases that violated not only the shrink-wrap agreement, but also the franchise agreement between the franchisees and McDonald's. And there were purchases of entire sets of more than 10 toys with a single food purchase, and some that were made with no food at all. The court actually saw the allegation would be true in some extent, and in the framework of other theory of laws. So the court ruled the forced sale doctrine may be involved when one of many sales is authorized by the intellectual property rights holder. And the forced sale doctrine provides that the ability of the intellectual property rights holder to control branded goods is exhausted after releasing them into the stream of commerce. However, in this case, the court saw the breach of franchise agreement as a result of franchisees' misuse of a franchisee's intellectual property rights does not necessarily constitute an actual breach of intellectual property rights. So it is the kind of contractual issue that will take a different avenue to be resolved. So it is preserved, operated in other theory, contract rights, breach of a franchise agreement. The actionable breach of intellectual property rights actually requires a distinctive element to be met as a matter of intellectual property. And Section 107 of the Copyright Act allows for certain fair use of copyrighted material without the consent of the copyrighted owner. The fair use doctrine allows others to use small portions of copyrighted works in the creation of another work. The borrower can legally make an authorized use of copyrighted materials in limited context. The most common contexts are in connection with the criticism of the work in the course of news reporting and for teaching purposes as a practice of the classes and as part of a scholarship or research activities that establish a valid defense against the infringement of copyrights. The determination of whether the use was fair is done on a case-by-case basis. The factors analyzed include the purpose or character of the use, such as whether it was of a commercial nature or for non-profit or educational purposes. The court also look at the amount of use in relation to the copyrighted work as a whole, and the effect of the use on the value or market of the copyrighted work. So you see essences geared up toward a understanding of a summary of this area of law, and the points of issue were litigated very extensively in Martel case, Martel Incorporation versus Working Mountain Production. And you see the third exemption, material in the public domain is not protected. These materials include government publications and materials whose copyrights have expired. A narrow concept in trademark law is the brand name, generic distinction. So it's a brand name or it is generic. So equivalent of a public domain in concept. The brand name can be protected as a trademark. However, if the name is used widely as a generic name, then it is said to have entered into public domain and is no longer entitled to a trademark protection. And in this line of studies, you need to know the authorship of a copyrighted work. Often, individual authorship would not provoke any kind of a dilemma or a kind of difficulties in finding a justice. However, in some cases, the author may undertake the writing in the course of employment. So the concept work for hire is the major exception to this right. Section 101 of the Copyright Act of 1976 contains a two-pronged test to determine if a work is for hire. So suppose if some competent professors write a treatise or other involved in research activities in partnership with other researchers of our campus, or then the work may be published in a collective name or some of a supervening brand, for example, Johnson University Press or others. Then how do you deal with this context in terms of a copyright protection? A work prepared by the employees within the scope of their employment is a work for hire. The Supreme Court in Community for Creative Nonviolence versus Right listed a certain factors to be used to determine when a third party who is not a regular employee can be considered as an employee for purposes of copyright ownership. And second, a work is for hire if it was specifically ordered or commissioned for use as a contribution to collective work as part of a compilation. The employer or person for whom the work was prepared is considered the author for copyrighted purposes. In the case of contributions to collective works, the contributor of the work retains a copyright for that individual's part, but the creator or producer of the collective work obtains a copyright on the collective work. So we need to separate between two concepts of authorship in this case, the collective work and also for the copyright for that individual part. Copyright protection is available for all unpublished works, regardless of the nationality of those. Published works are eligible for copyright protection in the United States if any of the following conditions are met. First, on the date of first publication, one of the authors is a national or is domiciled in the United States. Second, the work is first published in the United States or in a foreign country that is a party to an international treaty to which the United States is also a party. Or third, the work is a sound recording that was first fixed in a treaty country. And also the substantive requirement about protection of copyright would be spelled out in Berne Convention for the protection of literary artistic works. And also notice is waived in terms of the legal requirement. However, as I've said, it removes the infringer's defense of innocent infringement. Under the innocent infringement defense, infringers are absolved of liability if they can prove that they did not know the work was protected. So the notice could militate against this, the allegation of this kind of a defense. And the notice needed to use the copyright symbol, give the year of first publication and name of the owner of the copyright. And the practice was highly maintained until before the 1976 Copyright Act. The American Copyright Act was remodeled to follow the amendment of the Berne Convention. So the notice requirement was removed. And also, you are now on page 404A, which describes the patent protection in brief. U.S. patent law confers on the patent owner the exclusive right to manufacture, use, and sell the patented product or process within the United States for a period of 20 years. To fully protect it, the patent holder or patentee should serve notice by affixing the word patent or the obligation patent, together with the number of patent to patent item or product. The patent law states the failure to mark the package means no damages shall be recovered by the patentee in any action for infringement. The patentee will be able to obtain an injunction to prevent further infringement, but will not be able to sue for damages for injury caused by the infringement. So now the patent right is a critical instrumentality to increase the business interest, you see. And one trend would be charted in great use in about understanding of this patent flourishment. You see, have you subscribed the business magazine? Often they deal with other areas of concerns, management, personal affairs, others. Recently, the business magazine space many pages about patent and or technological changes or others. And once I read the story, patent trout, what does it mean? Patent monster. So now the kind of big enterprises or public universities compile the patent rights in monitoring context. You see? So now the international perpetrators will be cautious about infringement of patent rights. So the concept is getting into deeper and serious attention about due protection of patent rights. How do you consider? Is it imposing and unfair? It is a source of economic revenue, contribute very much to the national economy. So one concept we often stress in parts of the administration, like creative economy, scientific development, and as combined with the industrial wisdom, kind of a strategy we require to boost our national economy. And you see a doctrine of equivalence in terms of protection, patent protection. In this doctrine, an exact copying of an invention is not necessary to prove a case of patent infringement. The patent owner has to show only that there is equivalence between the elements of patented invention and that there is equivalence between the elements of the equivalence between the elements of patented invention and the infringing product. However, if the second invention is an improvement of the first, then the patent owner is not likely to benefit from the doctrine of equivalence. So the court often favors the promotion of inventions. It's a kind of public value to encourage inventive activities. And you see a case Warner Jackson Company versus Hilton Davis Chemical Company in view of a patent protection. The patent owner had developed a process to remove impurities from a commercial dyes. His process operated at pH levels between 6.0 and 9.1. It sought an injunction against the developer of a purification process that worked at a pH of 5.0 point. The Supreme Court held that the doctrine of equivalence must be applied to the individual elements of an invention, process, and not just the invention as a whole. The fact that both parties have developed the process for the purification of dye does not make them equivalent inventions. Instead, it needs to be determined where the process operates at the pH level of 5.0 is equivalent to one that works at 6.01. If the two processes were of equivalent quality, then the owner of the first process was entitled to an injunction on the doctrine of equivalence. If a process that works at a lower pH is qualitatively better, then it is to be considered an improvement and as such would be protected as a new invention. And also, one important statute would be Economic Espionage Act of 1996. What we call in abbreviation EEA. It was intended to protect a trade secret. this act makes it a crime to steal not only government secrets, but also business trade secrets. One issue recently explored is how to prove a violation of the EEA without first showing that there was a trade secret to be stolen. The court in the United States versus Sue held the defendants in a criminal case involving conspiracy to steal trade secrets in violation of the Economic Espionage Act do not have a right to see the trade secrets in question in an effort to prove that there were no trade secrets. In that case, Sue and others were indicted for violating the EEA by conspiring to steal corporate trade secrets regarding a valuable anti-cancer drug. The defense maintained the constitutional and procedural requirements of criminal prosecutions dictate full access to the documents so they could establish the defense of legal impossibility. The court ruled so long as the defendants believed they were going to steal trade secrets, it does not have to be proven that there were actually trade secrets to steal. So you need to know that it also brings the context the criminal response against infringement of trade secrets. And you see in title extraterritorial application of United States law. The operation of Lanham Act to deal with the criminal in this so it actually involved the international law theory about the national jurisdictions. The U.S. court perceived it is the right way to exercise its national jurisdiction over the person of the United States citizenship. However, it breaches in some aspect the territoriality principle, which is very embedded against the first-name jurisdiction. See? In this case, the production company of Scotch whiskey were allegedly on damage suit. So it falsified the brand name by marking Scotch whiskey. It is actually not a Scotch whiskey, so it is the perpetration of a infringing trademark. See, it's a forced robbery actually to a foreign licensee. And the U.S. company supply labels designating the product, the product as Scotch whiskey, as I said, and the licensee is a Panamanian enterprise. There was no evidence the adulterated whiskey was imported into the United States. Nonetheless, the court held the Lanham Act applied to the U.S. defendant, stating the law or principle of international law bars the United States from governing the conduct of its own citizens. So, the United States courts actually developed in a very systemic way to deal with kind of a extraterritorial application. One notable theory would be effect theory, where the subject matter triggered to govern impose the kind of influences kind of effect in terms of national economy in the United States, or some touches on the consumers in a direct or a constructive way to the detriment or interest. That kind of effect theory is standard to establish the ground of extraterritorial application of the United States law. In this case, it is actually conspicuous to focus on the personal element of citizenship also. Actually, the Scottish skill was not imported in the United States. It was sold in foreign countries, Panama or others. So it has no direct bearing about consumption of whiskey in the United States territories. In any case, the personal jurisdiction is one alternative to support the claim of a national jurisdiction as a matter of international law theory. And also, the gray market is concept which refers to imports being a genuine trademark but imported by party other than the trademark holder or authorized importer. It also refers to as a parallel import. So it is also one of contentious issues about international trade scholars. It is permissible or not. So in parallel imports, they include goods produced outside the United States pursuant to an intellectual property right transfer agreement, and goods licensed in the United States for export that are subsequently imported in the United States. In these instances, the U.S. licensor will find its own market territory undercut by identical goods produced under a foreign licensing agreement. So it actually undermines the commercial interest of the licensor. So it actually related the for sale doctrine, for example. So the copyright holders or patent holders entered into the license agreement to permit the use on a contractual basis with them. And that is one way to ensure against abuse of a infringement, patent infringement matter. So it is actually a concern should be landmarked in entering into the international business arena. So to reduce the agreement into contractual terms by instituting stipulating on license agreement matters. And also it is pivotal to expose himself or herself to the national intellectual property laws, where the technology would be imported, exported. So it actually in conflict of interest between the patent or trademark holders and the licensees. The for sale doctrine effectively evaporate the rights to foreclose to reselling others, as we have been introduced. However, in some interest, it actually disrupts the interest which could be conceived as a matter of right. The gray market problem as pertains to the U.S. domestic market involves goods that are legally produced and licensed and that are imported or imported into the United States. And in some cases, goods that are legally produced by U.S. foreign subsidiary or affiliated therefore and then imported into the United States. And the U.S. domestic market involves goods that are imported in the United States by a foreign firm after licenses or assigns its U.S. trademark rights to another. So, in dealing with this challenge, we need to see the context presented on case-by-case basis. In the first scenario, what do you see the justice about a gray market or parallel imports? The firm that is hurt by gray market imports often seeks to prevent the importation. Section 5 to 6 of the Tariff Act provides relief under the first gray market scenario if the license agreement prohibits such importation. So it is important to reduce the understanding of parties into writing, definite terms, in clarified way. The importance of placing restrictions in international licensing agreements to prevent the gray market problem is examined later, and that will be coupled in next class about the technology transfer or franchise agreement. The customs service will not prevent importation in the second scenario because the foreign entry is under common control of domestic company. However, Section 42 of the Lanham Act can be used to prevent the importation of foreign-made goods materially different than the same trademark goods produced in the United States. This is because of the likelihood that the U.S. consumer will be confused into thinking that the goods are identical. So, the different aspects of each transaction need to be scrutinized to find whether it is permissible or impermissible. And one other updated act about a music or a musical performance would be the Sound Recording Act of 1997 and is a progeny which differs, however, in cases, anti-bootlegging statute enacted in 1994. What is bootlegging? And what scope of Sound Recording Act intends to regulate the relevant dispute? In Columbia Broadcasting System case, there is history of special statute protection for music and musical performance. Musicians or performers may enjoy copyright or copyright-like protection in three things, which are important to keep distinct. First, a musical composition itself has been protected by statute under the Sound Recording Act of 1971. This means that the people who make an authorized reproduction of records or tapes can be prosecuted or face civil liability of performance already reduced to sound recording and commercially released, is conceptually distinct from a bootlegging, which has been defined as the making of an unauthorized copy of a commercially unreleased performance. So it actually covers the concept where perpetration occur in advance about the public release of others. It is one point of fear that the entertainers often be precaution about. The anti-bootlegging statute criminalized the unauthorized recording, the transmission to the public, and the sale or distribution of or traffic in unauthorized recording of live musical performances. And through the pages, you need to have awareness in summary about intellectual property rights protection. And critical institutions would be the World Intellectual Property Organization, what we call WIPO in abbreviation. And you see, Paris Convention is a major treaty about the industrial property rights. And the convention established a right of priority and to national treatment. So availing of a Paris Convention in process and in transactive registration across the global jurisdiction would be facilitated. The right of priority for a fixed period of time would serve the convenience and often uniform measure against the interested countries. A person who files for a patent or trademark in one member country is given a right of priority for a fixed period of time in other countries. The right of priority gives the holder 12 months for patents to file from the date of the first application filed in Paris Convention country. And also the Patent Cooperation Treaty, PCT, now accelerates the business needs of the international commercial merchants. So it brings about a very speedy transaction of patent registration and others. PCT entered into force in 1978 and is open to any member of the Paris Convention. To date, 127 countries have become parties to PCT. And also, in our purpose, the agreement of trade-related aspects of intellectual property, what we call TRIPS agreement, will be primary. You need to be exposed. And you see what a five sections which concerns copyright and related rights, and trademarks, and geographical indications, country of origin, and industrial designs and patents. The first three parts, so the five sections constituted a part 2, which is entitled Standards Concerning the availability, scope, and use of intellectual property rights. So this course presented to you through this class would pertain to this discussion. And you need to know that the substantive standards often borrows its legal devices from international treaties, notably a Paris Convention, Berne Convention, and Rome Convention. And the first three parts provide the general provisions. Scope of intellectual property rights and enforcement provisions. So the TRIPS actually is divided into parts, sections, and articles. And general provision and basic principles are titled for part 1. This part defines the principles of national treatment, most favored nation treatment, and the general objective of the agreement. So two representative principles, what is NT and most favored nation treatment, MFNT, should be applied to this area of law, intellectual property. And part 3 explains the type of enforcement mechanism country must provide for violations of intellectual property rights. The scope of enforcement mechanism is shown on the following, shown on page 4 or 58. So Article 44 covers injunctions. Article 45 damages. Article 45 indemnification of defendant. So it is the duty of member state to institute the kind of a level of protection about the patent right. And the standard would be minimum. So it is to be the best for the recognition of minimum standards for national intellectual property law regime. So the member state may elevate the standard in his own discretion and conscience and rationalization, of course. However, it is the covenant, the binding of member states of WTO, which is basic and minimum to be enforced in the nature of what is the mandatory nature. The member state should comply with. And in responsibility to enforce this agreement, Article 6.3 the TRIPS agreement are required to institute the Council for trade-related aspects of intellectual property. So it is principal actor to manage this TRIPS agreement. And notably, the TRIPS agreement also incorporates the transparency standards, which was set forth in Article 6.3. And this is a vital concept, as we noted in previous class. But in a request from the enterprises, the business world, it is one important troubles often the business persons often encounter. So transparency is essential. National laws or institutions need to be open and be given adequate notice about actions or dispositions. And publication requirement also will need to be satisfied. It also complies with the concept of due process. So, okay, actually, I've completed the TRIPS agreement. However, we are now busy of closing this class. Any question? Okay, thank you for your attention.